Hey everyone, this is Michelle Phillip from Soul Trees Right to the Point in conversation with Senior Advocate Mathews Nedumpara on the Indian Judiciary. We are here with Senior Advocate Mathews Nedumpara, and so thank you for joining me. I would like to ask you, in the light of the recent statements made by senior advocates Kapil Sibal and Dushyant Dave, where they stated that the judiciary is at its weakest, that the collegium is not taking on the government, and that lawyers are today afraid to speak. Please share your views on this, sir. These are very serious allegations.
I'm grateful to you for asking this question. Dushyant Dave says the bar is at its weakest, the judiciary is weakest, the collegium is functioning. The collegium is not performing, and it is unable to take on the executive. See, Dave, in some sense of what he said is right, but he is mistaken, thoroughly mistaken. He considered that it is the job of the executive, the judiciary, to take on the executive. He said that Modi is a very powerful chief minister, like as a prime minister. Never we had such a powerful prime minister. Maybe Indira Gandhi has been an exception. True. But the role of the judiciary is not to take on the government. Its role is not to act as an opposition. And the judiciary, I said, he is complaining that the judiciary is not hearing, he is not issues against the issues of governance. He is complaining that 7-judge constitution bench is not constituted, 9-judge is not constituted. And look here, nothing could be more outrageous than these kind of lamentation by Dave and Kapil Sibal. The whole institution is for them. The Supreme Court is not hearing anybody other than them. Only Dave, only Kapil Sibal, only Abhishek Manu Singhvi, and only these few 10 people alone are heard. And all time is taken for hearing their matters. All time is taken for issues which are it has absolutely no justiciable issues. The electoral bond issues, the demonetization issue, these are all, they may involve fundamental rights, violation of fundamental rights. Every issue involving fundamental rights are not justiciable. They forget the fundamental principle that the matters, when Parliament enacts a law, we are all present in the Parliament, symbolically present. It is with our consent that legislations are made. When a court takes a decision, it is between the parties. A court has a power to decide issues which lawyers know as something which are justiciable between parties. And now, look at I don't have a problem. If the Supreme Court has all the time and the Supreme Court takes up the issues of common people, real lists, somebody comes to a court when he is seeking where his house is forcibly taken possession of, or other fundamental legal rights are involved, the court is hearing them, and thereafter the court has surplus time and venturing into the domain of the executive, governance, etc. I don't mind it. Because I say that I don't say that there are no lapses in the governance. Maybe central government is fairly, the governance may be fairly good, but at many state levels, government levels, governance is pathetic. But the solution is not judiciary. Maybe Dave says the minorities' rights are infringed, or many other things he says may be true. But that all fall under the exclusive domain of, the governance, and that's a political issue. The solution has to, if Narendra Modi is bad, BJP is bad, they are anti-Muslims or anti-minorities, then that has to be fought where? In the political arena. You contest election, defeat Modi, that is the solution, not the court. And look at here the scenario here. I've been appearing for poor people, the people who face dispossession under the Surface Act, under the many draconian laws. And the court doesn't have even 1 minute to hear a case of the borrower or the case of a citizen affected by that. So where we have landed up. And I cannot blame the judges. See, look here, there are 70 cases, 60 cases, 70 cases listed before a judge. And I must say to their credit, the judges come red. I just told yesterday the Justice Sanjeev Khanna, your lordship should not come red. because you come read and take a stand and you are not willing to hear the lawyer for 1 minute. And the court pass an order, 99%, in the case of Justice Khanna, 99% of the all petitions are dismissed. And people complain that Justice Khanna is only hearing Kapil Sibal and Abhishek Manu Suni and others, nobody else is heard. Yes, that is he is going to be the future Chief Justice, but truth has to be said, that is the allegation. But I found him a gem of a person, very competent judge. He comes ready, and I see, as a lawyer, I found him, how much effort the judge has taken to study the brief, come ready, fine. The judge is a human being, nothing more can be expected of him. The judges of the Supreme Court they have been probably, the pressure of work is so much, and no judge should be under so much of the pressure of work. But, so this is why. This is because a lot of time of the court is spent, I should say wasted, on useless PAS, on issues which no way the court should ever entertain. The other day I was in the Chief Justice Court, then I think it's Uchal Court today, I think. And Dave was making a submission. I didn't exactly understand the case. Then the Chief Justice really agreed to constitute a 9-judge bench. If 9-judge bench and 7-judge bench are constituted, then the Supreme Court is the entire institution is brought to a calamity. Where is the time to hear other cases? Around 60,000 SLPs are filed in a day, in a year. And what is the total working hours of a court? Say maybe some 15,000 hours. And today the courts are in a situation not to allot 1 minute for a litigant who is denied a bail, whose properties are taken, he is deprived of a residential home. I have taken up cases of widows. Most of the cases which I have taken up from are of widows and the ladies, and the most, the one which they require the maximum, empathy. But the court has no time, not even 1 minute. So this is the issue. This is the issue. Supreme Court cannot and it should not enter into the political domain. It is not its job. It should not. And it will only bring disrepute to the Supreme Court. Political issues have to be fought elsewhere. I don't say that, I certainly won't endorse any totalitarian regime. If Modi is totalitarian, he has to be thrown out. And that has to be through a political process.
Thank you, sir. Sir, with all due respect, some of the cases that you mentioned, aren't they the jurisdiction of the High Court to decide these cases? You mentioned issues of widows being displaced and other things. What are your thoughts on this?
Now the problem is, ideally in an ideal system, the courts of original jurisdiction should be the lowest court, the civil court. Everywhere else in the world it works in that fashion. Nowhere in the world the Supreme Court is the first court of original jurisdiction. No system can work. If every citizen can approach the Supreme Court as a first court of original jurisdiction, then we need a Supreme Court of 1,000 judges. So that is, then the whole problem is, the High Court has become non-functional. And it's a very sweeping statement. And look at the case of Bombay High Court. You file madam, you are a teacher. You have a grievance. You go to file a petition in the High Court. 210 petition is filed. Then it is rejected. For X or Y reason it is rejected without a proper hearing. Then you have no right of appeal. There is no forum. Under Article 220 is filed a writ petition and is rejected. Then as a person aggrieved, you have no forum of appeal. And you talk about why a widow who's, for instance, in this matter, surfacing matter, where the widow's cases I took up, were cases where the banks have proceeded against, not the banks, the ARCs, that all, or something like a blade companies. They are involved in all sorts of nasty activities. And they move the magistrate, and the Supreme Court has said, don't hear anybody. That is the problem. And because of that, the magistrates pass orders even against a dead man. Without notice, I took up all those issues. before the Supreme Court, and when a matter came before, when I appeared online before Justice Chandrachud, his lordship asked me, why Nedumpara, why are you filing a petition under section, in challenge of section order passed by the magistrate under section 14, straight to the Supreme Court. Then before I could answer, I am muted. So they haven't answered. Because your lordship, the Supreme Court has directed the magistrates not to hear anybody, not to issue notice, and where magistrates and district collectors, before passing an order to take possession of a person of a residential home where they have observed the principles of natural justice, the high courts have even taken contempt of court proceedings. This is the draconian situation. So I had to rush to the Supreme Court because the magistrates are asked to pass an order without hearing the parties affected, even against a dead person. And look here, and the High Court, you come to the High Court. High Courts have been said, don't entertain. Supreme Court says High Court shall not entertain a petition. And see, when I started my practice 40 years before, High Court judges, they were very bold. They had said, no, we don't bother about the Supreme Court. Supreme Court judges may say many things. But we will do justice. We will do what is right. Today, Supreme Court judges, Chief Justice of the High Court go to the airport to receive, not the Chief Justice of India, even a judge of the, senior judge of the collegium. The independence of the judiciary is lost.
So Advocate Dave mentioned in his interview on YouTube that the collegium has failed because it has been appointing unfit, incompetent judges in the recent past. Can you explain that?
Same, the collegium's appointment, I would say incompetent, so this is a question of opinion. Yeah. Then I would say the collegium has only appointed a kith and kin only. And Dave also comes under the category of kith and kin. And that's the reason why he got designated at a young age, and he never stood against these discriminatory practices. So they said the British, they believed in divide and rule. And that is what the Supreme Court practiced in Supreme Court. They have classified lawyers into different categories: senior advocates, advocate on record, under advocates. And Dave has not spoken anything against on any of these issues. He has no reason to complain because he is a beneficiary of the system. He is the one who is the judges, very leisurely here. Fine, that is a different issue. Now he has said this collegium, the collegium is subservient to the government. The collegium has appointed only not very deserving the judges, etc. Now the question is, at the same time, I agree with him. At least certainly because whether competence, etc. cannot be measured. But when it comes to when I say that collegium has appointed only the kith and kin, that's a fact which is ascertainable. I have prepared a chart and sent it. Nobody can deny that X is the son of X former judge. Therefore, what I said is a verifiable, identifiable, undeniable fact. What Dave has said is a matter of opinion, whether competent, incompetent, and all. That's a matter of opinion. To an extent, I agree also that many who have not ever been deserving to be a judge has been appointed, and somebody even may have become Chief Justice even. That's a different story. The whole issue, if collegium is bad, what should we do? He is on the at one point he says that simultaneously collegium is bad. At the same time, he said for the government, not for following the recommendations of the collegium. So there's a double standard. Collegium is not in the constitution. The founding fathers wouldn't have ever thought of it, investing the power of appointment, everything to the judges. Judges' job is to do adjudicate dispute, not appointment of judges is a executive function. So it is completely unconstitutional. Dave himself says it is, the judges did it by rewriting the constitution. So he must support, and I am sure he will one day at least, for abolition of this collegium. And for the NJSC may not have been a perfect system, but it could certainly have been improved. And NJSC were a system where an independent mechanism which notifies vacancies, invite applications, and a transparent open selection is made. So he should I will join entirely with him, and I will certainly not suspect his bona fides. When he supports the NJSC, and when he says and join us and join the people of this country for abolition of the collegium, now today is on double standard. See, whatever comments Dave is certainly free to oppose BJP, absolutely nothing wrong in that. But Prashant Bhushan, all these people, Kapil Sibal are all using judiciary as a pawn against the executive. They must come out of their air-conditioned cabin. They must go to the streets, point out Modi government's failures and dictatorial tendencies, which they say they must fight it in the open. That's a political issue. It is a political field. They should not abuse the courts, misuse the courts as a pawn against the government. That is my difference.